And welcome to the first public meeting of the new year of the Standing Committee on Justice and Human Rights. It is an incredible pleasure to welcome our new Minister of Justice and Attorney General of Canada, Mr. David Lametti, to our committee for the first time. Welcome, Minister.
Thank you.
Congratulations on your appointment. I know that we are all very, very excited to work with you. And it's also a pleasure to welcome Mr. Barrett to our committee. Welcome, Mr. Barrett, and congratulations on your election.
Thank you.
And it's a pleasure this morning to be joined by Ms. Schultz as well. Welcome. And the minister this morning is joined by Mr. François Daigle, the Associate Deputy Minister. Welcome, Mr. Daigle.
Sure.
And a returning champion who has been here now, I think, a dozen times, Ms. Lori Wright, the Senior Assistant Deputy Minister. It's always a pleasure to have you, Ms. Wright. Welcome.
Thank you, Mr. Chair.
And the reason that the minister and the department are here this morning is the committee is commencing its study of Bill C-84, an act to amend the criminal code, bestiality and animal fighting. And for that reason, I'm also very pleased that Mr. Erskine Smith is joining us today and will be joining us for our hearings on C-84 as he was instrumental in helping the development of this bill. So welcome, Mr. Erskine Smith.
Thank you.
Mr. Minister, you have your opening statement and the floor is yours.
Thank you very much, Mr. Chair. Monsieur le Président, je suis heureux d'avoir.
Mr. Chairman, I'm very pleased to have the opportunity to appear before you today for the first time as Minister of Justice and to discuss Bill C-84, an act to amend the criminal code, bestiality and animal fighting. The amendments in this bill reflect our continuing commitment that of our government to review our criminal justice system in order to ensure that our laws protect the most vulnerable and reflect our common values. The in-depth review of our criminal justice system has resulted in essential bills that have been studied and thoughtfully amended by this committee. I thank you for the important work that you accomplish. And I thank you in advance for the work that you will be doing on Bill C-84.
Of significant consultation and collaboration with key stakeholders. We have received broad support on these amendments from child protection groups and organizations like the Canadian Federation of Humane Societies, the Canadian Veterinary Medical Association, and the Canadian Federation of Agriculture. I would like to thank them for their advocacy and support in this endeavor, which truly reflects a common ground approach to addressing a critical gap in the criminal code's bestiality offenses. I would also like to recognize the advocacy of many of our colleagues, including, in particular, Mr. Erskine Smith. Bill C-84 is a direct response to the Supreme Court of Canada's decision in the Queen against DLW, where the court found that, in the absence of a statutory definition in the criminal code, the common law meaning of bestiality is limited only to penetrative sexual acts. C'est pourquoi le projet de loi C-84 propose d'ajouter une définition du terme bestialité à l'article 160 du Code criminel afin de clarifier
of bestiality so that Section 160 of the Criminal Code will clearly apply to all acts that are for a sexual purpose with an animal. And here, I would like to add that the expression for a sexual purpose is used several times in other provisions of the Criminal Code, particularly dealing with child pornography at Section 163.1, luring at Article 172.1, and the fact of making sexually explicit material available to a child under Section 171.1 and is well understood by the courts, and that this expression does not apply to legitimate practices of animal husbandry such as artificial insemination and veterinary practices. In R versus Sharp that the Supreme Court of Canada handed down in 2001, the court interpreted the expression, and within the context of child pornography, that it considered that an act which was objectively considered was committed in order to serve the sexual gratification of the accused. Bill C-84 proposes to use this expression in the interpretation of the offense of bestiality.
Of children from sexual abuse, an objective which has always been a priority for our government and indeed all parliamentarians. With thanks to the important work by the Canadian Violence Link Coalition, including the Canadian Centre for Child Protection, we know more about the link between animal sexual abuse and the sexual abuse of children, as well as other forms of violence. Research shows that the commission of bestiality offenses are not isolated events, but rather are usually part of a pattern of vicious treatment of both children and animals. Bill C-84 therefore sends a strong message that bestiality is one of the most severe and violent acts against children, vulnerable persons, as well as animals, and that it has no place in Canadian society. En plus de combler cette lacune,
As well as dealing with this shortcoming in the criminal code, the bill also proposes to strengthen measures for the protection of animals by broadening the scope of the legislative provisions against animal fighting. Currently, the criminal code prohibits that anyone encourage combat or baiting of animals, and helping or assisting anyone under 445.11b to build, to create, or to maintain or keep a cockpit on their property that they own or rent, and to allow the arena to be built or maintained under Section 447. Each of these offenses would result in a maximum 5-year term of imprisonment on summary procedure, or a maximum fine of $10,000 or 18 months in jail. For many Canadians, animals constitute or represent an important part of our family, and we have the obligation to protect them, the duty to do so. In order to strengthen legal sanctions against animal fighting under the Penal Code, the Criminal Code, Bill C-84 proposes 2 significant amendments. First of all, it amends the offense for fighting of animals under 445.11b in order to correct a shortcoming. Currently, this offense prohibits anyone from encouraging animal fighting or baiting or helping or assisting in such. The bill proposes to broaden the scope of the offense in order to expressly prohibit anyone making any profits from animal fighting or training them, transporting them, or raising animals for the purposes of animal fighting. With a clear description of the prohibited acts that are proposed, it will be easier for police to lay charges and for the Crown to bring these people to court. Secondly, the bill amends Section 447 in order to broaden the scope of the offense, resulting in people who keep cockpits, and to broaden it so that it covers all animals. Currently, the only offense is for cockpits, and that doesn't cover other animals, particularly dogs. These changes are important because they allow for the clear banning of a vast array of behaviors that are often associated with this terrible crime.
Often animal fighting, especially dog fighting, takes place in Canada. However, we do know that it is a significant problem linked to organized crime, including illegal gambling and the illicit trafficking of drugs and weapons. Moreover, the dogs that are used in fights are often seriously wounded or killed. The proposed reforms would make clear that animal fighting is a cruel and abhorrent activity that simply has no place in Canadian society. I would also like to take this opportunity to clarify that these reforms to animal fighting provisions do not apply to any legitimate activities such as hunting, training, or the use of a dog for protection. This is important, and I know that many Canadians will wish to be assured of this fact. Avant de conclure, j'aimerais reconnaître que certaines
Before concluding, I'd like to recognize that certain stakeholders and parliamentarians are of the opinion that Bill C-84 does not go far enough in terms of increasing the protection measures for animals. Bill C-84 is intended to be a targeted response based on significant consultations to ensure a common approach in order to protect the most vulnerable. The bill responds to two specific issues that benefit from vast support on the part of the public, the provinces, the territories, and stakeholders in the area of child protection, as well as those defending animals. For example, the Canadian Humane Societies and the Canadian Agriculture Federation, the Association of Canadian Veterinarians, and 10 groups of stakeholders from the agricultural sector all asked for changes concerning animal fighting and bestiality.
Remind the committee that the impact of these reforms will provide significantly greater protection for children, vulnerable persons, as well as for animals. And while the proposed reforms in this bill are targeted at two of the most serious issues, our government is committed to ensuring that all appropriate protections are extended to the most vulnerable, and accordingly, will continue our comprehensive review of the criminal justice system for further amendments. I'm looking forward to hearing from Canadians on this, and I'm sure I will hear from the committee on this. Thank you for your time today, and I'm happy to take any questions that you may have.
Merci beaucoup, Monsieur le Ministre.
Thank you very much, Mr. Minister. And I think if we have time, we'll have 2 rounds of questions. In the first round, we'll begin with Mr. Cooper.
And thank you, Mr. Minister. Once again, congratulations on your appointment. I know you bring a great deal of experience, and I have every confidence that you're more than capable of fulfilling your duties as Minister of Justice. So congratulations again.
Thank you.
With respect to the bestiality loophole, following the DLW decision of the Supreme Court, my issue is not with the bill, Bill C-84. I fully support closing the loophole. I think all Canadians, the majority of reasonable Canadians, would support closing the loophole. My issue is with the time that it has taken to introduce legislation to do so. The decision of the Supreme Court was rendered in June of 2016. It is now January of 2019, and I know, Minister, you've just been appointed, so I'm not faulting you personally for it, but we're now 2.5 years. We probably, by the time this legislation goes through the Senate, it will be 3 years. 3 years in which this loophole exists. And as you pointed out, when we're talking about bestiality, we're talking about often a pattern of behavior that involves the most vicious of behavior towards animals, towards children. That's a common theme that we find, is that children are more often than not the victims. And indeed, according to the Canadian Centre for Child Protection and their December 2018 report, of 21 cases that they reviewed, more of the cases did not involve penetrative acts, and of the cases that didn't involve penetrative acts, all of them involved sexual abuse of a child. So, Minister, I guess my question simply is, what has taken so long?
It is a fair concern to worry about the length that legislative reform takes, the length of time that legislative reform takes. And certainly I agree with you, and thank you for your question. This is a serious issue, and I think the important thing to underscore from the beginning is that we are dealing with it. And so you are right, I believe, I agree with you, that this is a serious issue that needed to be addressed, and we are addressing it. There are other measures in the criminal code which obviously protect children against sexual exploitation. A number of provisions with which you are familiar, dealing with sexual interference, sexual exploitation, corrupting children, indecent acts, etc., as well as the sexual assault provisions and aggravated sexual assault provisions. So there is a group of existing provisions that do protect children. There are also provisions in the criminal code that protect animals where there's harm to the animal. So we are filling a gap. I wouldn't use the term loophole, but we are filling a gap in the Act, and we are moving forward with it.
Well, thank you, Minister, and not to belabor the point, but I do think it needs to be put on the record that in Bill C-84, the definition that is provided for is that in this section, bestiality means any contact for a sexual purpose with an animal. In 2017, my colleague, the honorable member for Calgary Nose Hill, introduced a private member's bill, Bill C-388, and the wording in Bill C-388 is, in this section, bestiality means any contact by a person for a sexual purpose with an animal. Identical language. Again, why didn't the government get behind Bill C-388 more than a year ago?
Look, I salute the work done by our colleague from Calgary Nose Hill. It is true that the purpose, at least as regards bestiality, was quite similar. We've gone further in this bill to add another area of protection, so the animal fighting provisions, which were also deemed to be of important by a number of different interveners and advocates in the area, as something that everybody could get behind and agree upon. So this bill actually goes further, but I do salute the work. I do salute the work that Ms. Rempel has done in putting forward that particular bill.
Thank you.
Thank you very much. We will now go to Mr. Erskine Smith.
Thanks very much, Minister, for being here. I also appreciate your support before you were Minister for C-246. I wanted to ask, your home province of Quebec has recognized that animals are sentient. I want to get at some of the general principles for why we want to protect animals in the criminal code. And you noted in your comments that animals are oftentimes an important part of our family. And would you agree that animals are sentient?
The evidence that I have seen, I think, is increasingly going in that direction. I'm not an expert. I can only base it on what I read. So to the extent that I have seen the same kinds of studies that you have, it seems to me that that's where the scientific evidence is going.
And in terms of the moral wrong that we're aiming to address in the criminal code, is it a crime to cause unnecessary pain and suffering to animals because they're sentient, they think and feel and can suffer pain, or is it because they're the property of someone else?
It's a larger question, and I think that question needs to be addressed as part of our ongoing look at these provisions generally. We've committed to that. My predecessor committed to that. I'm happy to commit to the same thing moving forward. I certainly am quite open to reforming all of the provisions generally, but that will take time, and it will take time precisely because of the questions that you're raising, important scientific questions and important ethical questions about our relationship to animals.
I think it gets to the bottom of what do we want the criminal code to look like in terms of protecting animals, and that will depend upon the first principles of what do we want to protect in the first place. And I think it's important when we know, and the evidence is that animals can think, feel, love, and suffer, our laws should reflect that reality. So there have been previous attempts by former Liberal justice ministers to introduce significant reform to the criminal code with respect to animal cruelty provisions. Justice Minister Anne McClellan, Justice Minister Martin Cochon, Justice Minister Irwin Cotler. These three previous attempts were more substantive than C-84. Do you think C-84 is sufficient?
No, I think it's been it was made clear by my predecessor, and I think it was made clear in my opening remarks that we have in C84 picked two areas where there's widespread agreement, and we could get it done now. We were filling a gap in one case, and we are addressing a practice in another case, animal fighting, that we don't want to see. Agree that there are larger, deeper ethical questions, legal questions that really do go to the heart of the way in which we envisage society and our relationship to ourselves, amongst ourselves, as well as to animals, and those are larger questions that need to be addressed.
And it's fair to say then that this is a first step. I would say a fairly modest first step if I'm being if I'm being generous. But this is a first step, and that as Justice Minister, you're committing to additional consultations and to doing more where those consultations find some consensus and find a way forward.
Yeah, as my predecessor also stated, we're going to keep moving forward with this dialogue and literally try to make our criminal code and our society better.
So, in keeping with that theme of additional consultations, I want to read a letter from November 22nd, 2004. And it says, Canada's animal-based sectors, as represented by the undersigned, wish to express our support for the swift passage of certain amendments to the Criminal Code, cruelty to animals provisions. Specifically, we are calling for the reintroduction and adoption of the measures contained in C-22. Now, that was signed by over 25 animal use groups, including the Canadian Cattlemen's Association and the Dairy Farmers of Canada. It was not signed by the Canadian Federation of Agriculture, but CFA did note their dismay when similar measures didn't pass into law. So it seems to me there was significant consensus in 2004 amongst animal use groups to be more bold and to do more for animals in the criminal code. And do you think, with sufficient work on your part, that you can get back to that consensus?
Look, I'm not going to speak about a consensus that happened in 2004. I wasn't privy to those discussions. I was, quite frankly, doing other things at the time, and so I'm not fully versed on all of those various discussions that happened in 2004. What I will commit to doing is keeping dialogue open with various groups, including a number of the groups that you've mentioned. I know that they have weighed in on this particular piece of legislation, and they're supportive. And we'll continue to be open to all people who have an opinion on the matter.
My last question, just to pick up on that point of dialogue. So this committee is going to be engaged in a few meetings of study and legislative review of a bill that is effectively one page and addresses two very narrow issues in the criminal code. And it's an important bill in the sense that it addresses a Supreme Court ruling of some note, as my colleague from the Conservative Party addressed. But it doesn't allow for a broad conversation at a committee like this. It doesn't allow for a multitude of stakeholders to come in and not just talk about these two provisions in the criminal code, but say, how do we as a society better protect animals across this country? And so do you think it would be more productive in terms of dialogue to have a committee like this, whether it's the Justice Committee or a special all-parliamentary committee devoted to animal protections, to say, let's bring in witnesses across the country. We as parliamentarians, it doesn't matter what party we're from, we care about ending animal cruelty, and to see what consensus we can forge to then introduce a new bill that would potentially do more for animals based upon significant consensus, based upon a larger dialogue that could take place at a parliamentary committee. Do you think that would be a productive way forward?
My immediate priority is the passage of this legislation. It is important. The two practices that are identified in this piece of legislation are important to prohibit and define in each respective case. I'm open to discussing other ways forward.
Thanks very much.
Thank you very much. Mr. Rankin.
Thank you, and I'd like to start by saying congratulations to you as a new minister. We're very glad to have you here, and I'm looking forward to working with you on this committee. I think my colleague, Mr. Erskine Smith, referred to this as a modest first step, which I think is a generous assessment of this bill. Sort of two things out of a long list of things that critics have been suggesting and promoting for many, many years. Indeed, we've had animal cruelty provisions in our criminal code since 1892 with only modest amendments since then. So I suppose it's a step forward. to have these. I'd like to ask you, building on what my colleague just asked, whether we ought to be moving toward a place where we're not simply treating animals as property, but are moving to put them in another part of the criminal code for more comprehensive reform. I've heard you say that this is a first step, that there's more to do, and you're open to doing that. I'd like to have you tell us when you see that broader reform that you seem open to actually beginning. When will consultations begin? When can we expect more comprehensive reform?
Well, I've just started in this job, and I have to admit that I enjoy the challenge. That being said, I'm not going to commit to a particular timeline today. I have in good faith said that I'm open to discussing moving forward in the future and to addressing the very concerns that you have raised, some of the deeper ethical considerations that may very well be evolving in society in a way that is more favorable to the treatment, positive treatment of animals. So I'm certainly open to that discussion, but I'd rather not commit today to a specific timeline.
Okay. On the animal fighting provisions that are you described as well, you mentioned in your remarks that animal fighting has been linked to organized crime, gambling, illicit trafficking of drugs and weapons. My question is, what can you tell us about the involvement of organized crime in this activity in Canada?
Well, there is a link that has been drawn. There isn't as much data as perhaps there might be, simply because a lot of it is covered up, and so it is. I will admit to a data gap there, and it is. But it is a link that has been drawn by enough credible information that it's an important factor. We're also protecting the animals themselves here too, and they are simply practices that we don't want to have.
So you mentioned protecting just now, Minister, the animals themselves, and you've amended Section 447 Sub 1, which is the arena for animal fighting, to broaden it from cockpits for fighting with birds, but to include dogs, as you mentioned. So why didn't the bill go farther and deal with the other subsection, 447 Sub 3, which would currently, it wasn't changed. It allows peace officers to seize cocks in a cockpit on premises where a cockpit is located. But that didn't get changed. So what do we do with dogs? Under the current section, you can seize the animals and, if necessary, have the cocks destroyed. But I don't see any changes to the provisions that deal with dogs. Is that an oversight that this committee may wish to amend, or is there no problem?
There is a traditional distinction between birds and animals that runs through the common law. There is a provision there specifically for roosters, for cocks, because they are often, sadly, very damaged in the fighting, and it is often the case they are also fed with steroids to make them more aggressive, and so, quite sadly, the birds, the most humane response to seizing the birds is to put them down. And that's not necessarily the case with all other animals. Remember that animals will also be dealt with under provincial legislation. And so there are protections for animals under provincial, which still abides even without this.
I understand that.
So the distinction there is because of that.
Yeah.
Certainly, if the committee wants to look at that as part of its study, then it might and has suggestions in that regard, we would be open.
But it did seem odd that you changed appropriately the section to deal with keeping an arena for animal fighting in Sub 1, and then in Sub 3, where you can seize one kind of animal, birds, you don't change it to deal with dogs. And you've told us, I mean, same thing you've talked about with respect to steroids, and the need for often for dogs, sadly, to be destroyed occurs when dogfighting happens. So I think it seems to me to be a deficiency. To suggest that the provinces have overlapping powers is, yes, that's true, but it just seems like we might as well finish the job in Sub 3 when we're here.
I think it's open for the committee to study that. My understanding is that there is always potential to rehabilitate a dog in a way that that doesn't exist with a rooster.
Thank you very much.
Okay.
Very much. Mr. Fraser.
Thank you, Mr. Chair. Thanks very much, Minister, for being here today, and congratulations on your appointment. Look forward to working with you. One of the questions came up earlier regarding, the amount of time this has taken to get put into legislation and come before our committee. I know that you said in your opening remarks the level of consultations that took place with a number of stakeholders. I'm wondering if you can elaborate on that and the fact that it took some time in order to hear from stakeholders to come up with legislation that would have their confidence. And I know you mentioned the Canadian Agricultural Association and a number of others. And I'm wondering if you can just go through the process of the consultations that took some time in order to have their input.
Well, that certainly was. It was undertaken before my watch began in this role. So I can't go into all the details in terms of the way people were consulted, and groups were consulted. But I can say Canadian Federation of Humane Societies, Veterinary Medical Association, Canadian Federation of Agriculture, representing 200,000 Canadian farm families. Other groups provided opinions in writing to the department, to the committee. So hunters groups, etc. So a wide variety of people were consulted. A wide variety of experts were consulted. Again, I wasn't the one leading those consultations, so I can't give all the detail on that.
Are you aware of changes that may have been made based on the input of those various organizations and groups?
Well, certainly clarity given on the definitions, both definition of bestiality, but also on the fighting provisions. Clarity was given to groups to differentiate the term baiting, for example, which doesn't mean baiting for the purpose of fishing or angling or other activities, but rather it's a way to incite an animal to fight. Harcèlement is the word used in French, and it's actually much more accurate than the Old English term baiting. Clarifications to make clear that this only applied to certain kinds of activity and not to other kinds of legitimate activity, including artificial insemination and other practices that are commonly used in the agricultural sector. So those sorts of things were the kinds of consultations that occurred.
Earlier in a question from Mr. Rankin, the issue came up regarding animal fighting, in particular its link to organized crime. I'm wondering if you can help the committee understand a little bit better the link between animal fighting and organized crime, and whether the measures in this bill will help reduce perhaps the ability for organized crime to take advantage of animal fighting and raising money.
Well, by prohibiting it, that immediately gives police a power to stop it in a way that they don't have now. They could do it with cockfighting, but they couldn't do it with other kinds of animal fighting. There was a study in Ontario, 2016, called Dogfighting in Ontario. Dogfighting, a Problem in Ontario, which began to draw the links between organized crime. So it's usually gambling. And then other associated activities, including drug trafficking and that sort of thing, that happens alongside. It will help. The fact that the whole activity is now prohibited will give police an additional tool when they have to move in and stop this kind of activity.
Very good. With regard to bestiality, the definition that has been arrived at, was there any survey done of other common law jurisdictions in order to ascertain whether there were other effective ways of dealing with the wording that ended up in the bill?
It certainly was. Now, the UK has the same definition that sadly was the case in DLW. So the UK definition does require penetrative sexual activity for its definition of bestiality. The United States doesn't. So common law jurisdictions in the United States which have dropped the penetration requirement, and therefore something closer to what we're moving to. another common law jurisdiction, Australia being a federal state, it's varied. Some of the criminal law in Australia is state to state, and so some of the states have a penetration requirement, some don't.
Great. Thank you. Those are my questions.
Thank you very much, Mr. Fraser. We will now move to our second round of questions, and we'll start with Ms. Khaled.
Thank you, Mr. Chair, and thank you, Minister, for coming in today, and welcome to our committee. I know that we have a very energetic and quite a cordial committee here. I just want to start by saying that I have never really had a pet myself other than tadpoles. That was my group of pets as a child, much to my mother's dismay. But I do appreciate other people's pets just as much as I appreciate other people's kids. And that social contract we have in sharing and in really loving and nurturing one another as a community and as a society. So in your opening remarks, and something that Mr. Cooper noted as well in his remarks, there's a link between animal sexual abuse and the sexual abuse of people, including children. And this is definitely an important link for us to understand so that we can help the protection of children from this horrible, horrible type of abuse. So can you please elaborate what that connection is and what kind of research is behind it and how this bill will impact that?
I mentioned in my opening remarks the Canadian Violence Link Conference 2017 that began to draw out some of the pre-existing data and research and that sort of thing. To put it quite simply, it's about vulnerability, and both children and animals are vulnerable, and so a sexual predator often will link both and use animals as well as children for their own sexual gratification. So sadly, the link is there, and the data is increasingly emerging that there is a link, and that people will often move from animals to children, and then both. So it's something that I think we need to send a clear signal in the definition of our criminal code provisions that all of this kind of activity for sexual gratification, and now the definition turns on that, any kind of contact for sexual gratification is prohibited.
Thank you. So we talk about really having that fulsome approach to providing safe communities. How do you think that this bill will impact that fulsome approach to making sure that our children, our pets, and families are safe, especially in light of Bill C-78, which passed through this committee with respect to divorces, and oftentimes that does impact. Animals are sometimes part of the family that is broken up. So how does it impact that fulsome approach?
Well, I think as legislators, any piece of the puzzle that we can improve upon. And there are many moving parts. So C-78 and the Divorce Act is one. Administrative justice reform that you've already looked at, C-75, moving forward, is another series of parts of improving the criminal justice system and the administration of justice. All of these pieces of legislation, whether they be social, whether they be criminal, help in some way, we hope, to improve the lot of families, improve the lot of children, and to better protect animals. And so I guess there isn't one single answer other than to say we're trying to get a number of things better, and we'll continue to do that.
Thank you. Those are the questions I have.
Thank you very much, Ms. Khaled. We'll move to Mr. Barrett.
Thank you very much, Mr. Chair, and Minister, thanks for being here today, and congratulations as well. This is my first time speaking at committee, and so I'm joining the program already in progress, so to speak. And to give you some context, my riding is an agricultural riding, and my family operates a small cow-calf operation. And I'm a hunter here in Ontario, and I appreciate the broad scope of consultations that were undertaken, and heard you list off some of the groups that were consulted, and understanding that the intent has been stated to ensure that the proposed law doesn't interfere with legitimate or traditional hunting, farming, trapping practices, and up to and including indigenous harvesting rights. What protects against legitimate hunting and angling practices that include baiting from being targeted when the proposed wording, and I understand that there is a more specific word in French, but in English, the word used in paragraph 445.1 sub 1 B is that in any manner encourages, aids, promotes, arranges, assists at, receives money for, or takes part in 1. The fighting or baiting of animals or birds, and as you know, fishing and hunting both use baiting. So what protects against that, in spite of the the preamble and the intention that was stated at the outset? What protects against that?
Well, the way in which the common law has defined baiting and the criminal law in Canada has defined baiting is I think more than adequate protection. And these concerns were raised by colleagues. Excuse me. By the way, welcome. Welcome to this committee and welcome to the House of Commons. It's a pleasure to have you. I know how hard it is to win an election, and so you deserve every congratulation, and you deserve your seat here. So well done.
Thank you.
Back to baiting, which we're not doing right now. You can rely on the criminal law and common law definition of baiting as being an activity to induce the ire of another animal. So bear baiting was a traditional activity that would be covered by baiting, whereas putting bait on a hook for the purposes of angling would not be. It's a different meaning, although the same word is used. And that's the specific way in which the criminal code uses baiting in this. And I think you can be assured that there's a tradition of interpretation of the word that protects hunters and anglers who may have to use some form of enticement for what is a legitimate practice.
Okay, and so that would include then, in certain minerals that are often used to entice, as you said, a deer, for example, and calls that would be used that provoke responses from the animals that advantage the hunter. Those would not be included, or they're safe from common law interpretation that would lead to criminalization of those practices.
Yes, that is correct. And I had said in the word in French, harcèlement, I think more adequately evokes the meaning that we want here, which is a way of provoking an animal to fight, as opposed to what is otherwise an enticement in a legitimate activity.
Okay, and with regards to farming practices, you'd mentioned artificial insemination as one. Were the groups that were consulted satisfied with the direction that was adopted in the proposed changes?
Yes, I have a letter here to my predecessor from the Canadian Federation of signed by the Canadian Federation of Agriculture, Canadian Federation of Humane Societies, Canadian Veterinary Medical Association, Canadian Cattlemen's Association, the Chicken Farmers of Canada, Pork Council, egg farmers, hatching egg producers, turkey farmers, Canadian Bison Association, the Mink Breeders, Canadian Sheep Federation, Canadian Poultry and Egg Processors Council. It's a pretty exhaustive
That's
group.
a comprehensive list.
Yeah.
Okay. Thank you very much, Minister. Thank you, Mr. Chair.
Thank you very much. Mr. McKinnon.
Thank you, Chair. And thank you, Minister, for being here. And I'd like to join the whole committee in welcoming you to this new role. And now for the tough questions. So I want to build on a question that Ms. Khalid introduced. She was speaking, I believe, more in terms of bestiality. I guess I would like to address the matter from the standpoint of cruelty and violence towards animals. So what does the current research on cruelty and violence toward animals indicate about the types of offenders who commit these crimes?
Well, I will admit to not having that psychological research in front of me. It is behavior that we are trying to get at, so prohibiting certain kinds of behavior that we're trying to get at with these provisions. But there is data that is beginning to be accumulated. The FBI in the United States has undertaken a data tracking survey to look at and analyze animal abuse and draw other sorts of conclusions from it. So I don't want to. I'm not a psychologist, so I don't want to pronounce on what kinds of conclusions might come from that. But we will continue as we move forward to look, to look at that data as it. I know that a number of colleagues around the table have raised concerns about a larger study that needs to be undertaken, and we will look at that kind of data as we move forward. Including the psychological data to which you're referring.
Thank you. I'd like to talk a little bit now about the stakeholder consultations. So, and it has been discussed that there are other aspects of animal cruelty that are not addressed by this. I wonder if there are any aspects of which you're aware that need to be addressed that are not currently addressed in the criminal code. And as a follow-up question, I would like to ask about how the provincial and territorial laws interact with the criminal code to protect animals.
Well, I'm happy to provide information. Certainly, there are the other private members' bills, C-246, that raised a number of different concerns that need to be looked at, continue to be looked at. And so I'd be happy to provide that information. To you. Remind me, Ron, the second part of your question.
I'd like, if you can.
Right.
Yes.
Provincial property laws generally will apply to animals. I appreciate. I know that Mr. Erskine-Smith was probably pointing us to a larger discussion about whether animals were property. As he knows, he's smiling. As he knows, I spent all of my career looking at both property and intellectual property as areas of study, and so property and civil rights fall under provincial jurisdiction. So there will be provincial legislation, whether it be in the common law jurisdictions or in the civil law, that deal with animals. Then there are also other areas of administrative protection for animals that would fall under provincial legislation as well.
Thank you. So there are also, I guess I'll move on to challenges in prosecuting crimes relating to animal cruelty and bestiality. What are the particular challenges involved there, and are police officers trained in any particular sense to deal with such offenses? And yeah.
Well, my sense is the challenges would be the same as with respect to the bestiality provisions. The challenges would be the same as with any sexual assault provision, where you have a vulnerable party. Vulnerable parties are not often people who readily go to a police station and file a report. Well, you're talking about children, for example. And so it requires other people to report, other people to know about it. And so all of the sort of investigative challenges that exist with respect to sexual crimes against children generally are going to, I think, be quite similar here. And again, we're trying to provide an additional tool, an additional basis for which people can be charged. We've alluded to some of the challenges that exist around animal fighting. in the sense that it's clandestine, so hidden to begin with, and secondly, often interwoven with organized crime, which adds another layer of complexity. But once again, we're trying to provide a basis for which our law enforcement authorities can move in and stop the practice. And then hopefully, I think generally, some of the administration of justice provisions that are contained, for example, in Bill C-75 will also help facilitate the task at the other end.
Thank you, Minister. Thank you, Chair.
Mr. McKenzie?
Thank you, Chair, and thank you, Minister, for being here. It's kind of a nice day. It's not very controversial. I think you'll find most people are pretty much in agreement with the changes that are coming. I would look at one of the things that Mr. Rankin raised about the seizing of the animals, and appreciate there is a difference between cocks and dogs. And if I might suggest to you, sir, that you're absolutely right. Dogs can be rehabilitated. Sometimes the owners can't be. And if you have the opportunity then to take away what they would consider their inventory or their tools at the site, and I think it would behove us from a federal perspective to put that in the legislation. And I appreciate also that people like the SPCA are generally involved in any of those situations, but it does give a whole lot more power to the people that are investigating and doing that, to be able to seize the animals, to take them out of there. And I'm wondering if that isn't a good amendment to add to the bill that would benefit everybody, government included, that those tools would then be added.
Thank you for that. Thank you for that question, and thank you for your good wishes. I think we have a pretty good bill moving forward. Your task as committee members is to look at it, is to give it a good hard look.
Appreciate that. The other part is that, generally speaking, and I'm just dealing with that part of the bill, if we could take away the people who participate, not the owners of the animals or the birds, but if there's a broader connotation here that people found as found-ins in the old law system, I think would go a long ways to prohibiting, if there's no money to be made, I guess that's my point, there's no money to be made by these people who own these dogs and birds, it would put an end to, or potentially put an end to, a lot of the emphasis on it, because they do get together for the gambling aspect and for the spectator part.
I mean, the criminal code provision is fairly wide in the sense that it's not just building the arena or having or owning the animals, but it's also anyone who. Sorry, that's a spam call that I can't block on a BlackBerry. I can block it on my iPhones, but I can't block it on a BlackBerry. I apologize. Everyone who commits an offense under the proposed act in any manner encourages, aids, or assists at the fighting or baiting of animals or birds. So that I think covers everyone in the room, and so there's a wide, right, as well as anyone who promotes, arranges, assists, receives money, or takes part in. So that covers not just the animal owners and the proponents, if you will, but.
Satisfied that the court would accept that as people being there. How you end up proving that they're assisting or benefiting or whatever the other terminology might be in the definition, but it's just one of those things I think that we need to be cognizant of. If there's nobody there, it doesn't take place.
Right. I think your point is well taken. I think the wording of the act covers all the participants, and therefore meets the concern that you're raising.
Okay, thank you very much.
Thank you.
Thank you very much. Mr. Rankin.
Yes, and Minister, a 2015 Environics poll that was done for International Fund for Animal Welfare indicated a vast majority of Canadian respondents would support changes to the code that would make it easier to convict individuals for animal cruelty. Now, today you've alluded to Bill C-246, which I know you supported. It's a bill my friend Mr. Erskine Smith introduced, but 117 Liberals voted it down. Our party supported it. It was a comprehensive animal cruelty reform bill. For the public who are watching this and for people deeply concerned about animal cruelty, of course, we're stuck with these two limited measures that you've brought into the code today, or your government is introducing now. The bill that my friend Mr. Erskine Smith would have had introduced would have gone much further. Problem, we can't go beyond what in this committee the reforms that are before us, these two very specific sections of the criminal code, two issues. So I guess for the people watching, I'd like you, because you alluded to the you said in C-46, in respect of Bill C-246, the need to continue to be looking at this bill. Again, I'd like to ask you if that's a measure that you and in your new role might be prepared to look at afresh.
Thank you. Thank you for the question, and obviously I share your concern. I won't say we're stuck with this bill. I think this is a good bill.
The committee is stuck. I mean, for people watching, we are limited to what we can do because your government brought in these very minor sections to the criminal code, a good first step, as it were. But I don't want people to think we have the ability in this committee, sadly, to go beyond that. Only if your government introduces such a bill can we do so. Is that not correct?
That is indeed correct. I just wouldn't characterize a good first step as being stuck with something. I think it's a positive step moving forward. I know my predecessor committed at the time we were discussing C-46, committed at the time to a more comprehensive review of animal protection legislation, criminal in the
coming
code
forward
and otherwise.
anytime soon.
Well, and I'm going to commit to continuing that process.
Great, thank you.
Thank you, Mr. Rankin. Mr. Minister, I just have a couple of closing cleanups. In Mr. Fraser's question, you had referenced in your response to 2015 report related to animal fighting. Would it be possible for you or the department to provide a copy to the committee of that report?
Absolutely. That's the dog fighting in Ontario?
Yeah.
Yes,
exactly. And then I just have two questions, short questions, just to come back to Mr. Barrett's comment on baiting. I know that you're going back to the old medieval bear baiting that they used to have in England, and I understand the common law has a long history of what baiting involves, and I completely agree it is never going to be interpreted as baiting for hookers or for anglers. However, in multiple bills, because I agree that the French word le harcèlement d'animaux is a much better term than the English term baiting. I mean, I don't want to suggest taking out baiting because I understand the common law history of it. But I've seen other bills where, for example, when the English term or the French term was ambiguous or a weird term that had other mentions, you would put them in brackets. For example, let's say baiting and then in brackets incitement or baiting in brackets provoking. Was there a reason that wasn't considered in this case? Because again, as we agree, I think baiting is not the term we would normally use in today's English for that.
There was a specific concern raised by one of our colleagues in the House of Commons about the use of the word baiting, and the response that came back seemed quite unequivocal that the word baiting in English in this context would only be taken to mean what was in animal fighting. We can go back and give you a more fulsome response in writing if you wish.
Sure. Thank you so much. And my other question relates again to another English term in the Act that I find different than the French term, and it would be the word assistat. I mean, in French we would say assister, but the word assistat is not normally what you would say to say attends or to. Why are we saying the word assistat in English as opposed to if the intention is attends or takes part in, which is really what the French term is saying? Why are we saying assistat?
Right. I'm frankly not a legislative drafter. I have the similar knowledge of English and French as you do, and so I don't know if there's a technical meaning to assistat in English in a legislative drafting sense. And again, we can.
Could we ask just that question as well
to provide that answer to you? That would be fine.
Thank you so much. And I think on a cleanup point, Mr. Erskine-Smith has another similar question, if that's okay, and if anybody else has cleanup question. Yeah.
Less of a question than a point on baiting, just so the committee is clear. From some of the questions, I got the sense that people thought that the word baiting was being added to the bill, but the word baiting has been in the criminal code for decades and decades and decades. So to the extent that you had concerns, Mr. Barrett, previously, or today, your concerns would have been there 10 years ago. So that the amendments that today, or in C-84, are adding words around fighting and baiting, but they're not adding the word baiting.
No, understood. So, Mr. Minister and department officials, I want to thank you so much for briefing our committee, giving us the answers that we needed, and it's always a pleasure having you here, and I'm sure there'll be many more times where we'll be seeing you here.
Thank you. It's always a pleasure.
Thank you so much.
Thank you.
Meeting adjourned.